If you are renting anywhere in the United Kingdom right now, stop and watch this entire video. What I am about to tell you could save you from losing your home completely. This information could also save you thousands of pounds you did not even know you were owed. Your landlord is counting on you not knowing what the law now says about your rights. The rental law in England has changed in a way that affects every single renter right now. These changes are already in effect, and they apply directly to your tenancy as of today. Most renters across the United Kingdom have absolutely no idea that any of this has happened. I will walk you through every single thing your landlord can no longer legally do to you. When you hear some of these changes, your jaw is genuinely going to drop with complete disbelief. Some of these illegal things your landlord may have already done to you without you knowing. If that is the case, you may be owed real money that you can legally claim back right now. Stay with me until the very end, because every single minute of this video matters for you. Let us start with the biggest change in UK rental law in nearly 40 years of history. This is a change that millions of renters have been fighting for over many decades together. For decades, millions of renters across England lived in constant fear of a Section 21 notice. If you have ever rented a home in the UK, you may have feared this notice yourself personally. It allowed your landlord to remove you from your home with just 2 months' notice and no reason. No explanation needed, no warning given, and absolutely no fault required on your part whatsoever. You could be the most perfect tenant, paying every single month on time without any fail. You could keep the property in absolutely excellent condition and be a wonderful, caring neighbor. And your landlord could still hand you that Section 21 notice and simply say, "Get out." Can you imagine living under that kind of fear every single day of your life at home? Millions of families with young children lived under that constant, devastating shadow every day. Millions of elderly renters with nowhere else to go lived in permanent fear of that notice. Millions of long-term tenants were suddenly told to leave with absolutely nowhere else to turn. Some lost their homes simply because their landlord decided they wanted to sell the property. Others were removed because a landlord found someone willing to pay slightly more in rent. And some were evicted for absolutely no reason because Section 21 never required one at all. That entire era of fear and injustice is now officially and permanently over for good. As of the 1st of May 2026, Section 21 has been completely and permanently abolished in England. Your landlord cannot hand you a no-fault eviction notice anymore because it no longer legally exists. It is completely gone and finished forever. Any Section 21 notice today is totally illegal. If your landlord tries to evict you without a valid legal reason, they are breaking the law. This is part of the Renters' Rights Act 2025, the most powerful tenant protection law ever passed. Over 11 million renters across England are now protected by this incredible landmark law today. And most of those 11 million renters do not even know this law currently exists for them. But you are watching this video, and by the end, you will know exactly how to protect yourself. Now let us go deeper, because abolishing Section 21 is only the very beginning of these changes. There are multiple things your landlord can no longer legally do to you under this new law. The first thing your landlord can no longer do is evict you without a proven legal reason. Your landlord must now prove in court they have a legitimate legal ground to remove you. They cannot simply decide they want you gone and hand you a notice without proper justification. Their legal reasons are very specific and very limited under the new Renters' Rights Act today. If they cannot prove their legal reason before a judge, then you stay in your home completely. This is a historic shift in power, moving firmly from landlords directly to you, the tenant. Your landlord must now use a Section 8 notice citing a very specific legal eviction ground. If that ground does not hold up properly in court, the eviction simply cannot go ahead legally. You have the right to be fully heard at any court hearing and present your case properly. Court must always be involved now. There is no more quiet removal with a door letter. This protection applies to you right now, whether you have rented for 1 month or 10 years. The power has permanently shifted away from landlords and firmly toward you where it belongs. Now let us move to the second thing your landlord can no longer do. This one is huge. The second thing your landlord cannot do is use a fixed term ending to force you out. This enormous change is something almost nobody in the country is currently talking about loudly. Under the old system, landlords gave you a 12-month contract with a clear written end date. When that date arrived, they could simply say your contract is finished and you must leave now. Even if you desperately wanted to stay and had done absolutely nothing wrong at all ever. Landlords used the fixed term ending as a quiet and very effective no-fault eviction method. Landlords loved this tool because it required no justification and no court proceedings whatsoever. Tenants absolutely hated it because it left them with no real security or stability at all. That entire practice is now completely and permanently illegal across England starting right now. From the 1st of May 2026, all fixed-term tenancies converted to assured periodic tenancies automatically. In plain English, your tenancy now rolls on indefinitely with absolutely no end date attached. Your landlord cannot let the clock run out and then tell you that you must leave now. Your home is your home for as long as you choose to stay, provided you follow the rules. This extraordinary protection now belongs to millions of renters who are completely unaware of it. If your landlord says your tenancy ended because the fixed term expired, they are completely wrong. If they try to make you leave on that basis alone, they are potentially breaking the law. Do not pack your bags or hand back your keys because the law is firmly on your side. Now let us discuss the third thing your landlord cannot do. This could save you hundreds yearly. The third thing your landlord cannot do is raise your rent more than once every 12 months. Before this law, some landlords were aggressively increasing rent multiple times within one single year. They use repeated rent increases as brutal pressure tactics to force tenants out without formal eviction. It was completely legal at the time, deeply cruel in practice, and happened constantly across England. Under the Renters' Rights Act, your landlord can only raise rent once per year. That is the limit. If they try raising rent more than once every 12 months, they are breaking the law entirely. But it gets even better because the law goes much further than just the once yearly limit. Not only can they raise rent once a year, but they must give 2 months written notice first. They must use a specific legal form called a Section 13 notice to inform you of any increase. An informal letter, text message, or verbal notice from your landlord is simply not legally sufficient. If they do not use the correct legal form, that rent increase may not even be valid legally. And if you believe the increase is above market rate, you can take it to an independent tribunal. That tribunal has legal power to decide your actual rent, not your landlord or their agent. Your landlord cannot simply name a number and demand you pay it from next month without challenge. This powerful tool is available to every renter in England right now, and most have never heard of it. If your rent went up more than once in 12 months, document everything and contact Citizens Advice. Now let us discuss the fourth thing your landlord cannot do. This locked millions out of renting. The fourth thing your landlord cannot do is demand several months of rent from you up front. This was a completely discriminatory and completely legal practice across the UK until right now. Landlords routinely demanded 3 months, 6 months, sometimes even more upfront before giving keys. This locked out thousands of renters who could not pull together such a massive lump sum payment. It hit people on lower incomes hardest, those on benefits, young renters, and newcomers to England. Under the Renters' Rights Act, your landlord can only ask for 1 single month of advance rent. 1 month is the absolute legal maximum, and demanding more means they face serious financial penalties. Even if you voluntarily offer more than 1 month up front, the landlord legally cannot accept it. The moment they accept more than 1 month in advance, they have committed a prohibited payment offense. Penalties for landlords breaking this rule are significant, and local authorities can investigate and fine them. This change has opened rental doors for thousands who were completely and unfairly shut out before. If a landlord demanded more than 1 month advance rent from you recently, you can report them. Now let us move to the fifth thing your landlord cannot do. This is perhaps the most important. The fifth thing your landlord cannot do is refuse you for receiving benefits or having children. This was one of the most widespread and quietly accepted forms of discrimination in UK renting. Rental ads were openly and shamelessly saying no DSS, meaning no people on government housing support. Landlords flatly refused to even read applications from families with children living with them. This discrimination is now completely and permanently illegal, and landlords face very serious consequences. Your landlord cannot reject your application simply because you receive any form of housing benefit. They cannot reject you because you have children living with you. This is now illegal discrimination. If a landlord rejects you for either of those reasons, there are legal remedies available to you. Millions of people previously shut out of large rental market sections now have full legal protection. If you were refused a property because of your benefit status, you can formally challenge that decision. If you were refused because of your children, the same applies, and you should seek advice today. Now let us discuss the sixth thing your landlord cannot do. For pet owners, this changes everything. The sixth thing your landlord cannot do is refuse your pet request without giving a good reason. For years, millions of pet owners across the UK were excluded from huge sections of the rental market. Blanket no pets policies were completely standard across thousands of properties with absolutely no exceptions. Under the new law, you now have the legal right to formally request permission to keep a pet. And your landlord cannot simply say no without providing a legitimate and reasonable justification for refusal. If they refuse without giving a genuinely good reason, you can challenge that refusal through proper channels. This might sound small, but for millions of pet-loving renters across England, it changes absolutely everything. Now let us move to the seventh thing your landlord cannot do. This made renting expensive for everyone. The seventh thing your landlord cannot do is encourage or participate in illegal rental bidding wars. This particularly ugly practice became increasingly widespread as the UK rental market grew more competitive. When multiple applicants wanted the same property, some agents would deliberately create an auction environment. They encouraged applicants to outbid each other by offering to pay above the clearly advertised rent. This artificially drove up rents everywhere and punished people who simply could not afford to keep bidding. Under the new law, your landlord must advertise a property at a fixed price and stick to it. They cannot invite or accept offers above the advertised price under any circumstances whatsoever now. If someone tries to offer more than advertised, the landlord must legally refuse to accept that offer. Now, here is something critically important that every single person watching this needs to fully understand. These rights I have described are not optional extras your landlord can choose to offer or remove. Your landlord cannot insert tenancy clauses that remove or reduce these legal rights in any way. The law is completely clear that any clause contradicting the Renters' Rights Act is automatically invalid. It does not matter how official or professionally drafted your tenancy agreement appears to look. If any clause contradicts the Renters' Rights Act, that clause is completely unenforceable in any court. Your landlord cannot contract out of this act no matter what they tell you or put in writing. Even if they pressure you to agree to something removing rights, that agreement has absolutely no force. Now let us talk about the financial penalties landlords face, because this gives the new law real teeth. Your landlord now faces serious and significant financial penalties for breaking these new legal rules. We are talking about civil financial penalties of up to £7,000 for certain violations today. In more serious cases involving repeated or deliberate breaches, that penalty rises to £40,000. Local authorities across England now have substantially enhanced powers to investigate non-compliant landlords actively. They can inspect properties, demand documents and records, and access third-party data for verification purposes. They can issue very significant financial fines to landlords who are found to be breaking the rules. The era of landlords quietly breaking rules with absolutely no meaningful consequences is genuinely ending now. There is also something called a rent repayment order that could put real money back in your pocket. A rent repayment order lets you apply to a tribunal to reclaim rent you already paid your landlord. Through that legal process, you can potentially recover money paid while your landlord was breaking rules. If your landlord has been doing things they should not, you may be entitled to get money back. This is a real established legal tool available to you right now, not something vague or theoretical. Here is exactly what you need to do next, based on everything you have just heard in this video. First, if your landlord sent you any notice to leave since the 1st of May 2026, do not panic. Check very carefully whether that notice is based on a legitimate and specific legal ground today. If it references Section 21 in any way at all, that notice is completely illegal and has no force. If the notice is vague or unclear, contact shelter or citizens' advice immediately and get free advice. Second, if your landlord raised your rent more than once in the last 12 months, document everything carefully. That may well be unlawful under the new act, and citizens' advice can help you challenge it properly. Third, if your landlord demanded more than 1 month of rent in advance, that is a prohibited payment. Fourth, if you were refused housing because of benefits or children, you have grounds to challenge that refusal. Contact shelter or citizens' advice immediately because their guidance is completely free and genuinely life-changing. I want to say this one final time because it is simply too important not to repeat it clearly. Over 11 million people across England are now protected by the Renters' Rights Act, including you right now. These rights belong to you personally. They are not favors your landlord generously chooses to grant you. They are not optional extras, and they are not subject to your landlord's approval or their opinion. They are the law of this country, and they apply directly and immediately to your tenancy right now. If your landlord is not respecting these rights, they are not just being difficult, they are breaking law. Please share this video right now with every single renter you know, your family and your friends. Most of them do not know what you now know, and this knowledge could genuinely protect their home. If you found this video helpful, please like it right now so more renters can find this information. Subscribe to UK Housing Alert and hit the bell so you never miss an important housing update again. Your home is your right. Know your rights always, and never let anyone ever take them from you.